Hello everyone, thank you for joining me on this video today. My name is Bernie Payne and I'm an independent legal and compliance consultant, primarily supporting recruitment agencies and consultancies. Now, I absolutely appreciate that tax is not everyone's favourite subject, particularly because it's only been a few months since the dreaded off-payroll rules went live in the private sector. So everyone's trying to avoid having to think about tax right now. But I do think it's important for agencies to understand and think about their ever-increasing tax obligations and to find ways to better identify, mitigate and manage those risks. But there's very little help or guidance in the market generally as to how agencies should address their tax risks. Hence today's topic. Tax regulation is becoming one of the greatest operational challenges to recruitment agencies, much more so than rights-led legislation and case law. Tax legislation is often far more complex and more difficult for a non-technical audience to understand and therefore to implement. So it's often not addressed or as proactively managed, as well as some of the rights-led legislation such as agency worker regulations or the conduct regulations or similar. An increasingly common feature of tax legislation, particularly as it relates to the staffing industry, is the use of what we call strict liability measures. What that means is your intention is irrelevant. You don't have to intend to be non-compliant in order to be liable. So it doesn't matter that you've tried to do the right thing. If you're not obeying the letter of the law, then you're held accountable. And this completely conflicts with the long-held belief in this industry that if you've broadly understood your obligations and acted with good intention when trying to comply, that's probably enough to absolve you of liability. That's simply not the case with any legislation that imposes strict liability. Another approach that HMRC has used in recent legislation is to reverse the burden of proof, meaning that agencies have to prove to HMRC that their approach is compliant and robust, as opposed to HMRC having to prove that the agency has not fully complied with some regulation for some reason. Some really good examples of this strict liability approach are the Onshore-Offshore Intermediaries legislation, the Criminal Finances Act, and the enabling legislation. But there are others as well, including, incidentally, the role of the fee payer within the off-payroll rules. Now, I'm not going to go into detail about each of these pieces of legislation today, but I will spend the next couple of slides talking about the Criminal Finances Act. The Criminal Finances Act came into force in 2017, and it created a new corporate criminal offence for failing to prevent the facilitation of tax evasion. So that means all companies are now under an obligation to take active steps to prevent tax evasion, whether by themselves or by their suppliers and their supply chain. The Criminal Finances Act applies to all companies and all types of tax evasion, both UK and abroad. If you fail to take active steps to prevent tax evasion, then your company is exposed to an unlimited fine and potentially a corporate criminal record. Interestingly, the CFA, as we generally refer to it, doesn't require direct tax non-compliance by you. Your company can be held liable under the Act even if you didn't know there was any tax evasion going on, even if you didn't benefit from that tax evasion, and even if you had no criminal intent, providing someone else in the chain did. What that means is your involvement in a supply chain where there is a non-compliant provider who's evading taxes, that's sufficient for you to be held liable under the CFA. And of course, the labour supply chain is particularly high risk, and an easy win for HMRC. So they are targeting recruiters using the Criminal Finances Act in order to try to force the staffing industry to work much harder to ensure tax compliance throughout the supply chain. So on the surface, if you're involved in a supply chain that has any element of tax evasion, you're exposed to liability under the CFA. However, you will have a defence where you can show the following. You've conducted in-depth risk assessments to identify areas of potential exposure. You've conducted robust and thorough due diligence on your supply chain. You've adopted proportionate procedures to prevent tax evasion from occurring at all. Your staff and suppliers are all made aware of the CFA and its implications and your obligations, and everyone has undergone sufficient training to be vigilant in identifying potential tax evasion. And finally, that you continuously monitor and review your risks and your mitigation strategies. You won't have a defence to the Criminal Finances Act unless you can show you've done all those things. And the first part is the risk assessment. So you have to do one. But if your risk assessment considers all types of tax non-compliance, not just criminal tax evasion, well then that risk assessment will be much more helpful to your business as a living working document, because it'll mitigate your risks under all types of tax regulations. But where do you start? Well, I always start big and then get into the detail from there. So first step, what types of tax do you need to consider? Well, employment-related taxes are probably your highest risk areas. They're by no means your only risk. So do think about other types of tax, including VAT, corporation tax, etc. Make sure any international operations and taxes are also included. And if you make placements of any contractors outside the UK, even if you don't have your own offices in those countries and you use international payroll companies, for example, those placements still also need to be assessed for risk. The best way to get the most comprehensive insight is to bring together a group of people from across all aspects of your business. Representatives from all functions, front and back office, should be involved. You really want as many viewpoints as possible because different people will think of different risk scenarios for you to consider, but they'll also come up with different mitigation strategies and ideas. Whenever I'm helping clients with tax risk assessments, I always set them up in a table form and usually using an Excel spreadsheet. The areas on the right-hand side of this slide are the main headings that I would use as a starting point. So firstly, you start off identifying the risk and how impactful it is on your business. Then you consider the mitigation strategies that you already have in place and how they offset those risks, as well as identifying further actions or ideas to implement in the future. And I'll talk through each section in more detail in the next couple of slides. Employment taxes are likely to be the section with the most scenarios or risks, depending on how many contractors you have and the types of engagement models you use. So I would list out all those engagement models as a starting point. And then for each engagement model, consider every possible way in which you or your suppliers could be non-compliant. Make sure you consider all the tax legislation you're currently required to comply with, because that will also help you identify potential risks. So you know that if you supply PSCs, for example, you have the off-payroll rules and managed service company legislation to consider. If you engage PAYE umbrella companies, well then you're thinking about the offshore intermediaries legislation. If you engage sole traders, whether directly or through an intermediary, then you're exposed to the onshore intermediaries risk. Going through all the tax legislation you're already having to comply with, as well as considering the wider potential for tax evasion or avoidance, will give your risk assessment a much wider and more comprehensive scope. You should also be mindful that not all tax non-compliance is deliberate. So you need to think about accidental non-compliance, mistakes. For example, you're engaging with PAYE contractors, but you make an error when you're calculating the tax and national insurance contributions for a particular worker. What are the implications and risks in that scenario? Once you've brainstormed all the potential risks, you assess the impact on your business if that scenario was to materialise. Now that might be the financial impact, an impact on your reputation, or even your ability to provide your services at all. Then you discuss what you already do now to mitigate against that risk and how those mitigation strategies affect the risk. And then you discuss what additional actions or steps you could take to minimise the risk still further. And once you've done all of that for all of the UK related employment tax risks, then you do the same thing all over again for any international or non-UK placements you make. So I'm going to run through an example to help you get to grips with how to complete the assessment. Now this slide covers the risk side only. The next slide deals with the mitigation of that risk. So our high level heading is UK employment taxes. Its subheading is the more specific risk area, and in this example we're thinking about umbrella companies. Then in the third column, the risk that's been identified. So in this scenario, the risk is that the umbrella is operating an offshore payment scheme with contractors. Now, that clearly won't be your only risk with regards to umbrella companies. There'll probably be 4 or 5 at the very least, but that's the example we're using today. Now we need to determine the impact on your business if that risk was actually reality. And because of the offshore intermediaries legislation, you, as the agency dealing with that umbrella, are primarily liable to HMRC for any tax loss where an offshore umbrella is involved. So it's not the offshore umbrella or even the contractor who HMRC will pursue, it's you, the agency using that umbrella, who HMRC will go to first for unpaid taxes and national insurance contributions. On that basis, the impact of that scenario happening in your business is high, because you could be liable for all the unpaid taxes and national insurance for all contractors in your business using that offshore scheme. So the financial impact is high, and so is the reputational impact if your clients or your other contractors find out about it. The likelihood of the scenario materialising, well, that's probably medium, based on the fact that there are lots of good compliant umbrellas and hopefully fewer non-compliant umbrellas in the market generally. Therefore, your gross risk, if you like, is high because the impact is high, and when you multiply that with the likelihood, which is medium, the two of them combined give you a high risk. Now, it's important to work off the worst case scenario when you're identifying and assessing your risks. Don't reduce the impact or likelihood levels of the risk based on what you do to mitigate those risks. That comes later. So this half of the risk assessment is all about the risk without any mitigation from your side. So be brutal and assume the worst. Now we move on to how your actions affect the identified risk. You start off by listing out all the good things you do in your business to mitigate the scenario from occurring at all, or to reduce its impact if it does. Now, obviously, the strategies I've included in the first column on this slide are just examples of what you might do, albeit they are very common for most agencies. Once you've listed out all your strategies, then you decide as a business how strong those mitigation attempts are. In this example, the strategies to minimise this risk are pretty strong because they address multiple areas. That takes the net risk, if you like, of an umbrella company in the chain operating an offshore scheme down from a high, which we saw on the previous slide, to a medium level. But you don't stop there. You also consider what additional actions you could or should take to minimise the risk still further. And an example given on the slide is to conduct spot checks on payments made to contractors by any umbrella company you use, and not just asking for copies of payslips, but also the BACS transmission made by the umbrella to the contractor's bank account and the RTI submission to confirm that all the relevant payments have been made to HMRC for that individual. Finally, you need to identify the owner of that risk and the additional actions to take. That's not to say that you'll immediately implement the additional actions, but you have the ideas documented and you can follow them up at the appropriate time. Here's a quick look at what the sheet might look like once you've completed a few different areas or scenarios. Now, obviously, this covers just a few examples and the font's too small to read easily in this format, but you can see that using a traffic light system of colours to highlight the risks makes it easier to identify which scenarios present the greatest dangers to your business, and therefore those are the areas to prioritise when implementing any additional actions in the future. So to summarise then, make sure you involve every functional team in the risk identification process, including brainstorming those scenarios. The more viewpoints involved, the more likely you are to get the best, most comprehensive outcome. Consider all types of tax and all types of ways in which you engage contractors and other suppliers. Work out the worst case scenario first. Don't try to downplay risks until you reach the point that you're discussing your mitigation strategies. Make sure the owner of the risk, so legal or finance or compliance, follows up on those additional actions and ideas as part of their quarterly or annual work planning, starting with those actions that will have the most positive impact in reducing risk. Don't just do the risk assessment once and then put it away for a year. Make sure it's regularly reviewed and new risks considered or existing risks changing in terms of their impact or likelihood. Reviewing the risk assessment could easily form part of the normal agenda for your quarterly board or management meetings, for example. And finally, make sure all your staff are aware of your commitment to tax compliance, that any policies and procedures you put in place are properly communicated both at induction and on an ongoing basis. Because if your staff know that tax compliance is taken seriously, they're less likely to become involved in any non-compliance themselves and more likely to report any suspicions or concerns that they might have in relation to particular suppliers or contractors. They really are your eyes and ears on the ground, so make sure they understand your position and commitment to good tax practices. That's it from me. Thank you for watching, and please do check out my website for more helpful information, content and videos.